The British judicial system. After 1,000 years of restructuring in 2009, the United Kingdom judicial system finally became a fully independent branch of government. The United Kingdom judicial system is unique because three separate legal systems fall under its umbrella. By its very nature, it is a complex system worth further study. The judicial branch of power in Britain is headed by a monarch and is rather complex, partially because of the lack of real written constitution. Due to this, one can name the four law sources there: the legislation, acts of Parliament, the common law based on custom and historic rules. The European Union law deals mainly with economic and social cases, and the European Convention of Human Rights guarantees all persons basic rights protection. There should be a single system, but the United Kingdom has three of them: the Northern Ireland for England and Wales for Scotland. They are different by form and manner of operation, even carrying the same names. They are governed by different laws. These three systems reflect the historical origin of the previously independent United Kingdom's parts. The Queen appoints judges by the Parliament's advice and limits the sentences for convicted criminals. The executives can force judges to act in such or another manner as the latter should be conservative and apolitical self. The MPs can make a petition for judges' removal. In fact, this right was exercised only once in 1930 in Scotland. The United Kingdom Supreme Court is the last court of appeal for all three court systems and is the main court that handles constitutional issues. The country's court system has over the 1,000 years history. The Ministry of Justice administrates it. The British judges operate independently from the government. There exist specific courts for different types of cases: the magistrate and the county courts, the Crown and the High Courts. The Court of Appeal and the Supreme Court appeared only in 2009. They deal with public, civil, private and criminal laws. The criminal trials are to be held in open court with the 20 or 50 in Scotland juries who should make a unanimous decision. Meanwhile, in Northern Ireland, the trials for terrorist acts may be held juryless in the country. The structure of the court system in Britain is mainly layered. The courts in Great Britain are divided into two large groups: criminal courts and civil courts. Besides, there are many special tribunals, independent judicial bodies set up by Parliament. Criminal courts are magistrates' courts and crown courts. Magistrates' courts are the courts of first instance. Cases involving minor offences begin and end there. Cases involving more serious offences normally start in magistrates' courts before being referred to higher courts, crown courts, for trial. Crown courts try serious cases such as murder, rape, arson, armed robbery, and so on. Civil courts include country courts as the courts of first instance and the High Court as a higher court. Jurisdiction of country courts is now statutorily unlimited, and the number of cases tried at this level is vast. The High Court of Justice consists of three separate subdivisions: the Queen's Bench Division, the Chancery Division, and the Family Division. They are independent of each other and deal with different cases, both criminal and civil. Appeals against decisions of the High Court and the Crown Court may be taken to the Court of Appeal with its criminal and civil divisions. The Constitutional Reform Act 2005 established the new Supreme Court of the United Kingdom to replace the Appellate Committee of the House of Lords. The main reason for the establishment of this court is to separate legislative and judicial powers in the country. The Supreme Court took over the judicial functions of the House of Lords and started to operate in October 2009.